Okay, good morning, everyone. Thanks very much for being here this morning, and thank you for giving me the opportunity to talk to you all today. As she mentioned, my name's Tom Haren. I'm an attorney at Frantz Ward, and I have the distinct privilege of being able to work with a number of license holders here in Ohio's medical marijuana control program, some of whom are local first-time cannabis companies here in the state of Ohio, and some who have been operating for years throughout the country. And before I start, can I just get a show of hands? How many people here are actually working with cannabis clients now? Okay, great. That's super helpful. How many people here would like to work with cannabis clients? Okay. I don't know if I have a clicker. This works? Okay, no problem. Some of the things that I'm going to cover here this morning are covered in greater detail at other points of the CLE today and tomorrow, but I do think it's important for some overall context to touch on some of these things, at least briefly. And we've got an hour and a half, so if anybody has questions, feel free to shout them out or raise your hand at any point during the presentation. I'm happy to field questions as we go. Let's start with a brief snapshot of where Ohio's program stands currently. Ohio's medical marijuana control program is divided into various types of licenses. We have cultivators who will grow the medical marijuana, processors who will take that plant material from cultivators and turn it into other types of medical marijuana products, including oils, tinctures, edibles, that are by rule not attractive to children, so we're not going to see medical marijuana gummy bears here in Ohio. We might see lozenges, some type of nondescript gummies for people who that's the most effective way to dose for them. Patches that you can put on your skin for localized pain, so if you have a bum knee and you're using medical marijuana for pain relief, you can put a patch right on your knee and get dosed directly to the spots that are hurting you. And then vaping is something that's permitted as well under Ohio's medical marijuana law. You can't smoke medical marijuana. You can buy plant material at a dispensary. So like you see out west where there's a jar and it's got, you know, the bud, the prototypical bud that you think of when you think of medical marijuana. You can buy that here in Ohio, but you have to insert it into a larger vape cartridge. You won't be allowed to smoke it here in the state of Ohio. There are two different types of cultivators that are licensed under Ohio's medical marijuana control program. There are level 1 cultivators, which is, and the only difference is space. It's the size of the business. Level 1 cultivator can cultivate up to 25,000 square feet of medical marijuana cultivation area, which is your flower and vegetation stage of the plant. So a little bit of background. There are various stages of the plant cycle when you're growing medical marijuana. You typically start off with a clone or a seed. So you're either growing straight from a new seed or you've taken a plant that's about yay big and you cut off a stem and then you use that stem to grow a new medical marijuana plant. So you go from your clone room to your vegetative room, which is where you're just pumping that plant full of light so it grows as quickly as it can. You move it into a flower room where you wait for that plant to mature a little bit. And after the flower room, you harvest the plant, you dry it, you cure it, you trim it, and then it gets shipped off either to a dispensary or to a processing entity. So in Ohio, we've divided our types of cultivators into level 1s and level 2s, with the flower and vegetative space being called the cultivation area. So level 1 cultivators can have up to 25,000 square feet of cultivation area initially. Level 2 cultivators can have up to 3,000 square feet of cultivation area initially. And each of those cultivators can petition the Department of Commerce, which regulates cultivators and processors and testing laboratories, to expand that area. You can go from 25,000 to 50,000 to 75,000. Or if you're a level 2, you can go from 3,000 to 6,000 to 9,000 square feet of cultivation area. The Board of Pharmacy is responsible for licensing dispensaries and registering patients and caregivers. By rule, the Board of Pharmacy can license up to 60 dispensaries. So far, they've licensed 56 of those dispensaries. And the Department of Commerce has licensed 13 level 1 cultivators, 13 level 2 cultivators, and so far 14 processors. There are still 26 other processor licenses that can be awarded. The department is just a little bit behind and has issued some requests to processor applicants to submit some other information to allow it to award those next 26 processor licenses. The state has also licensed 5 testing laboratories. So before a product can make its way to a patient, it has to be tested for things like pathogens, fungus, bacteria, heavy metals, and things that might adulterate that product. And it also has to be tested to verify the cannabinoid profile in the product so that the patient knows what's the THC level, what's the CBD level in that product. Ohio has not formally started registering patients yet, but we expect that to happen later on this year. There was an initial goal to have the program operational, quote unquote operational, by September 8th of this year. We have blown way past that deadline, and I don't expect the program to be meaningfully serving patients probably until first quarter of 2019. I think we're probably looking at around February or early March at that point. Ohio is going to have one of the most robust medical marijuana control programs, or medical marijuana programs in the entire country. One of the reasons being that Ohio's list of 21 qualifying conditions includes chronic pain. We've seen in every other state that recommendations for medical marijuana for chronic pain make up the large bulk of recommendations that are written by physicians in other states. Ohio also has a very reasonable THC limit or THC content limit in medical marijuana. If a patient's buying plant material, that plant material can have up to 35% THC, which is up on the high range of the maximum amount of THC you're going to get from plant material directly. And then the THC limit for extracts for those other products is 70%, which again, it's not the highest in the whole country, but it certainly is not the lowest. There are some states that don't allow any THC in medical marijuana products. Call those the CBD-only medical marijuana states. As you all probably know, marijuana still remains completely illegal and prohibited under federal law. It is a Schedule I substance. It's a substance that has no recognized medical benefit and a high potential for abuse. We've run into the unfortunate scenario under federal law where they can't reschedule marijuana because there's no research that backs rescheduling it or descheduling it, but you can't do research on it because it's a Schedule I substance. So we're in this sort of loop where everybody sort of recognizes that having cannabis as a Schedule I substance doesn't make a whole lot of policy sense, but that's sort of where we're at. We'll talk a little bit about some unfortunate tax consequences for cannabis businesses. There's a particular section of the Internal Revenue Code that prevents cannabis companies from taking standard business deductions like you might be able to take if you were any other kind of business. Access to banking is very limited in this industry because of the conflict with federal law and the fact that marijuana remains totally illegal under federal law. We'll also touch on the fact that the FDA has some pretty clear guidance that marijuana cannot be sold in compliance with any existing FDA guidelines, even if it's like a hemp-derived CBD oil, which we're going to touch on as well. Trademarking can be a big problem because in order to trademark something, it has to be in lawful use in commerce. It's hard to convince the United States Patent and Trademark Office that your cannabis trademark is being lawfully used in commerce because it's unlawful under federal law. And the signals that we've gotten from the federal government about how or whether it's going to enforce these federal prohibitions has not always been clear and even at times can conflict with themselves. So in 2015, 2013, there was a memo issued by then Deputy Attorney General James Cole. And this was really the start of the fast growth of the cannabis industry, because this memorandum said, essentially, United States attorneys should not prosecute state-compliant cannabis companies if they're not implicating one of 8 specific federal enforcement priorities. If it's not a front for a cartel, they're not using weapons, they're not selling to children outside the back door, if they're in strict compliance with state law, etc. So as long as you do those things, the federal government can look the other way. Well, in 2016, when Donald Trump was elected, he nominated and the Senate subsequently confirmed Jeff Sessions to be the new Attorney General. Jeff Sessions is an ardent prohibitionist, and earlier this year, he rescinded that Cole memo and gave total full discretion back to the local United States attorneys to enforce federal marijuana law as they saw fit. Now, it's been the case, that memo was rescinded in January. We're now almost a year later. We have not seen federal prosecutions for state-compliant cannabis businesses, and most United States attorneys, including the U.S. Attorney for the Northern District of Ohio and the Southern District of Ohio, have basically taken the position, we got bigger fish to fry than state-compliant cannabis companies. As long as you are still not implicating those federal enforcement priorities, we are going to focus on opiates, human trafficking, and gang-related activity, the types of things that federal law enforcement has typically focused its priorities on. And in addition to that guidance from law enforcement, there's also been some conflicting movement from Congress. Congress has not changed the Controlled Substances Act, but what they've done is they've enacted spending prohibitions through the budget process that prevent the Department of Justice from using federal funds to interfere in state medical marijuana programs. And what that's meant, and we've seen prosecutions be tried out west, we've seen some prosecutions actually up in Michigan as well, and courts have held that that means if a company can prove it is in strict compliance with its state's medical marijuana laws, the federal government cannot prosecute them. The problem is that those spending prohibitions need to be enacted with each new appropriations. So it's always, everybody always holds their breath whenever there's a new budget or a new spending bill, because it's never really clear up until the very last second whether those riders are going to be included in subsequent budgets. But they've been included since 2014, and actually the new Republican champion of these spending prohibitions is Ohio's own Dave Joyce from the east side of Cleveland. He has one of the large Ohio cultivators in his district, and is now taking steps to ensure that state-compliant cannabis companies are protected in some way from federal interference. So let's talk about 280E briefly. A little bit of historical context. In the 1980s, there was a cocaine trafficker that wrote off his business expenses for trafficking in cocaine. And the reason is, under federal law, you have to pay taxes on all income. And the IRS doesn't care if that's legal income or illegal income. You still have to report it. You still have to pay tax on it. Remember, that's how they got Al Capone, right? This guy wrote off his cocaine trafficking expenses, went to tax court, and the judge said, yeah, he gets to do that. Because he has to pay taxes on that income, he can deduct his expenses in earning that income. Congress, understandably, was none too pleased with that ruling, so they enacted 280E. And what this says is you cannot write off your business expenses for drug trafficking activity. What you can take are cost of goods sold, because cost of goods sold aren't really a deduction. They apply to how you calculate that net income in the first place.